Why is this a major development? Because there's been a lot of talk out there. And I decided I'm going to just do a show tonight as part of my launching my Immigrant Survivor show, which I'm going to talk about later in this broadcast, to talk about this particular development first tonight. Why is this a major development in American immigration law? See, my friends, for decades, adjustment of status inside the US has allowed many immigrants to obtain green cards without having to leave America. That process has often protected immigrants from triggering severe immigration penalties that is tied to departing the US after overstaying. Because when you overstay in the US, you come in with a visa that allows you to stay for 6 months, but you stay for 9 months or 1 year, like many people do. When you go out, there are consequences. So most people who are qualified or who want to adjust a green card, they've been able to do it inside the US without having to go out so that they don't trigger those consequences. So here's the big danger now. If certain immigrants are now forced to leave the US to do consular processing abroad, this may trigger 3-year bar for unlawful presence exceeding 180 days. Because if you are in the US more than 180 days illegally, when you go out, you cannot come back for 3 years. That has been the law for a long time. And if you have been illegal or unlawful in the US for more than a year, if you go outside the country, you cannot come back for 10 years. That's a 10-year bar. Whether you are married to American citizen, whether you win lottery, whatever it is that you got, if you go outside the country, if you have been illegal for more than a year, you're not coming back for 10 years unless you get a waiver. I hope you are following me, where this policy is going. This means that some immigrants who leave the US can suddenly become barred from returning for years unless they qualify for what they call immigration waivers. And those waivers are not easy. Some of them take years before they even make a ruling on them when you're outside the US. I've had waivers that have been pending for 3 years that they've not even decided for clients that are outside the country. If you are inside the country, it's a whole different ball game. But once you are out, now you are at the mercy of the embassies. This is why this policy announcement is causing major policy concern among immigration lawyers nationwide, because they just increase the difficulty of our job by what I call the order of tenfold. Yes, because we can do and undo when you are still here. We can challenge immigration decisions in federal court. We can appeal. But when you're outside the country and looking in, you become a problem of the State Department. And that is a major hurdle.